Good evening and welcome to you all. This is a most interesting seminar and I hope you will find it enjoyable but informative. The death of George Floyd has focused the world on the issue of racism. There have been reactions of all kinds, some hostile, some destructive. Racism is both wicked and stupid. It is wicked because it is generalizing, dehumanizing, and it relieves the racist of responsibility for behaving properly to others. It is stupid because it is generalizing and in a negative way, and because it obliterates the quality of the individual who is on the receiving end of racism. It leads to injustice. Therefore, it's right for the Inn to look at this issue. This is not a question of what has become called virtue signaling. And for the Inn to do this, that would be an empty thing to do, a gesture. The proper question for Grays is to consider, how should we act? Are we doing what we should? We are in the process of setting up an outreach group which will look at this issue and carry on to others. And it's headed by one of the panel members this evening, Ijeoma Omambala QC, who is you will hear from later. The results of this evening's discussion will be taken into account by that group and will be an important part of their thinking and part of the Inn's look at its own responsibilities when the outreach group reports to the rest of us. And so I'm going to now move to introduce the contributors, the panel members, who are with us, and I'm going to take them in alphabetical order. Firstly, we have Fitzrene Headley, who was called to the bar by the Inn in 2011. She's a specialist in matrimonial finance, practicing from QEB chambers. And she also has worked closely with the education department as an ethics trainer and a mood trainer. We have Kim Hollis, who most recently has been Director of Public Prosecutions for the British Virgin Islands until late last year. She has previously been Chair and Vice Chair of the Equality and Diversity Committee of the Bar Council, serving in those capacities for 12 years. And when she was appointed QC in 2002, she was the first female QC from an Asian ethnic background. Next, we have Saad Hossain QC, who is a commercial silk, a member of One Essex Court, with a very varied practice covering High Court, commercial litigation, and international arbitration. He's co-chair of the Bar Council's Equality, Diversity and Social Mobility Committee, and also, of course, a member of the Inn. Next, we have Gelaga King, who practices both in the United Kingdom and in Sierra Leone. He's been a fee-paid judge since 2000, served for many years on the Bar Council's Race Relations Committee, and later was Vice Chair of the Equality and Diversity Committee. And he is Vice Chair of the UK Sierra Leone Pro Bono Network and has many connections with groups involving BMAE members. And he was a founder member of the African, Caribbean and Asian Lawyers Group, which has had a significant impact in helping BMAE students. Next from him, I hope I get the order right, we have, as I've said earlier, Ijeoma Omambala QC, having recently taken silk She's had a successful career as a senior junior, specializing in employment law, equality, regulatory and public law. She's a mediator and sits as a legally qualified chair of the Medical Practitioners Tribunal Service. She's a very experienced advocacy trainer, very highly regarded in the inn in that capacity. And we are very grateful to her for taking on the responsibility I've mentioned already of the outreach group. Next, we have Kwame Boateng Sekyere, who's a BPTC student at City Law School, and he's had already a distinguished career. He's the current recipient of the Shakespeare Memorial Trust Scholarship and previously recipient of an Anne Ebsworth Scholarship. So he has distinguished himself already. He works with secondary school students in Croydon to help them develop the skills they need to reach the BPTC and to have the confidence to try for the bar as a profession. And that is a very important aspect of what we will be considering this evening. And so I'm glad to say that we are also joined by Anesta QC, who is going to moderate the session this evening. Anesta was appointed Queen's Counsel and Recorder in 1999, and she has a practice in serious crime and in corruption. She has done a great deal of appellate work, particularly in the Privy Council, and she was counsel, notably, to the Stephen Lawrence inquiry, and she's a past Master of Advocacy for Gray's Inn. I think the Inn can be very proud to have people of this calibre engaging in this way with this issue, and I'm very grateful to all of them. And if Anesta's ready and
yes,
settled, I shall hand over to her to moderate this evening's session.
Thank you very much, Master Treasurer, for the introduction and for introducing all of us. My apologies, you may have thought I was not about to turn up. I had a slight crisis to deal with, but everything's now in order. I'm going to start off really with picking up something that the Treasurer said in relation to George Floyd. None of us will ever forget him. Neither will we forget the thousands of Black and white people, and I say that as a general remark, who together marched in protest in the US and here in the UK during COVID. So my first question to the panel is this. Now that we see the support for Black Lives Matter from non-BAME people in the UK, is now a good time to reduce Black-only organizations to allow for the increase in racially mixed organizations to deal with issues of unfair treatment on the grounds of race? Or do we just continue to tackle the issue in separate camps? So, Gelaga, would you like to start with this question?
Thank you, Anesta. Well, dealing with the first part of your question, I don't think there is such a thing as a Black-only organization. If by Black-only organization, the question means organizations such as the Society of Black Lawyers or the Black Society Network or the recently formed Black Barristers Network, then I think it's important that we remember that all of these organizations have as their raison d'etre equality, justice, and fairness. And they're not, in fact, exclusive organizations in the sense that they are inclusive, and they are open to anybody who shares their values of equality and fairness to join. So I think so far as there being Black-only organizations, I think there are organizations that fight for equality and justice, and they are not exclusive by nature. Dealing with the second part of the question as to whether or not it's time to move away from two camps. As far as I'm concerned, there are only two camps in this debate. One camp has racists in it, and the other camp has non-racists in it. And so far as the non-racist camp is concerned, that has always been one that has included both Black people, white people, and people of all races, creeds, and religions fighting together against injustice, whether it be in the civil rights movement, so that in the march, for instance, the Montgomery March with Martin Luther King, you will see that there were white people marching shoulder to shoulder with him. If you look at the fight so far as the struggle against apartheid is concerned, again, you will see that there were white people who fought hand in hand. And of course, we can't forget that when slavery was abolished, people like William Wilberforce were at the forefront. So the struggle against racial inequality has always been one that has united right-minded, right-thinking people. I think what we're seeing so far as the Black Lives Matter in its broader movement is concerned is that the younger generation are no longer prepared to accept a status quo that continues to preserve inequalities. For them, it's not enough to assert that one is not a racist. They want to see some positive action to dismantle some of the institutions that steadfastly remain unwilling to change. So that would be the way that I would answer that question, Anesta.
Thank you. Can I turn to Fitzrene, please?
I'm going to disagree just ever so slightly in relation to Black spaces, for example, because I think they shouldn't be exclusionary, but I do think there's a room to have somewhere that's a safe place, for example. So if you are, say, a very junior barrister and you want to be able to talk to people who've got the same experience of you, that might be somewhere you can do that. So I do think there's a space for it. Where I do agree is that there's also got to be a mixture of who is then in the, what I'm going to call the non-racist camp. You've got to be able to have allies in there, and to have allies, you need to be able to listen and understand. So I think there's got to be both the sort of safer place, sort of all Black or all BAME groups and organisations, not that they're going to be exclusionary, but that there's a right time and place to involve allies who can then assist in what we're all fighting for together.
Thank you very much. Saud, perhaps you'd like to follow on.
Well, I'm going to agree with both Gelaga and Fitzrene, even though they slightly disagreed with each other. And so just from a purely pragmatic point of view, what one sees, for example, in some women's based programs or meetings is that you find that there are venues that are intended to be safe places, events where which are designed to champion and mentor and so on. They have a particular focus in mind, which is gender, but they're not exclusive to gender. So those events are in fact open to all, but have a particular focus. And I think that that works quite well and strikes quite a good balance between what Gelaga says and also what Fitzrene says about safe spaces.
Thank you. I'm delighted to say we have a relevant question from our audience. I think it actually is rather helpful to have it now so that our next panelist, Kim, or the follow-up can deal with it. And here's the question. Do the names of groups need to change? As these are inclusive, perhaps the names need to reflect that. So, Kim, you can deal with that question if you wish.
The short answer, as far as I'm concerned, to that question is no, the names of the groups do not need to change. I agree with Gelaga because in my experience, there has been in recent years a very welcome steady rise in the membership of Black and Asian organisations from other ethnic groups, contributing to the racial mix and, in my view, strengthening the reach of such organisations. The impetus, in my view, in order to take this further and to strengthen it further, and ultimately the message, is in order to enable them to ensure that any strategies or messages are more than just aspirations. And the in my view, can actually contribute towards this by targeted outreach as well. For example, to the Society of Asian Lawyers and all the other organisations that have been mentioned, by lending their weighty support from some of their more senior members, by example, by committing to the support and monitoring progress in any strategies, i.e. positive actions. But no, I don't feel that the names need to change, but that's my view.
Thank you, Kim. Ijeoma.
Thank you, Anesta. For me, this is not an either or. I think that there is a need for racially diverse groups who campaign on issues of race. And I think I would take issue with Gelaga and Fitzrene to this extent, that there are not two camps consisting of non-racists and racists. There are two camps which consist of anti-racists, that is, those who have made a positive commitment to challenge discrimination on grounds of race in all its forms. And then there is the rest. As far as Black or Black-led organisations are concerned, I think that they occupy a particular space and serve a particular function. I agree with Fitzrene that there is a need for safe spaces and that these organisations can serve that role. There is, of course, always a need for allies, and that is where other organisations, as Kim and my other colleagues have said, come into play. But frankly, there is more than enough racism for all of us to challenge. I don't think we need to eliminate any group.
Thank you, Ijeoma. And Kwame, please.
Certainly, and I think it's important to echo one of the key points that's been made already, and that is that anybody who has the ambition and the target to combat racism in an active way is an ally. There are no separate camps between people. Black organizations or Asian organizations or multinational organizations, anybody who seeks to target racism is pushing it from the same camp. And so I think as these issues develop and as they come to the surface more, we will see this identification of these groups. However, this doesn't require us to then consider splitting or changing names, but to continue to develop as we've seen it being developed so far in the wake of the George Floyd killing.
Thank you very much, Kwame. And I hope that everybody was able to follow that. There were a few crackles, but we have a great IT person in the background who I know is going to deal with that. Again, just because it is relevant, Master Butcher has asked this. BAME, certainly from the Guardian point of view, is not a very attractive term and should be discontinued. Just a show of hands if somebody wants to deal with that one point. I know, names, we shouldn't get too worked up about them, but not everybody likes BAME. Yes, Ijeoma.
Well, I'm not a fan of the terminology, but as I think others will perhaps say, it's the least worst option when one is in a group like this discussing issues like this. In terms of a personal descriptor, I would never describe myself as a BAME person or a BAME individual, but I respect the rights of others to do so if they wish.
Thank you. I think we must move on now because we've got quite a few, I hope, interesting questions to go. One of the two most important stages of a barrister's career are obtaining a pupillage and then obtaining a tenancy. That all important two steps to get the opportunity to earn a living. So my question to the panel is this. Some people in barristers' chambers and outside of chambers consider that it is time to take action to ensure that more BAME lawyers get tenancies. We hear talk of positive discrimination, positive action, use of targets. Well, can chambers use all of those three actions to get BAME lawyers into chambers? Now, Ijeoma has a specialist in employment law. I'd quite like to start with you, if I may.
Okay, what I'm going to do is summarise the legal position very briefly. I'm not endorsing it, I'm simply trying to describe what the position is at the moment. So taking
Yes.
items in turn, the first thing that you spoke about was positive discrimination. And that's generally understood to mean treating somebody more favourably because they have a particular protected characteristic. Here, we're talking about race. So you're treating somebody who is of a particular race more favourably than someone who's not of that race. That's not lawful, and therefore, I suppose, chambers shouldn't do it. Positive action, on the other hand, allows a recruiting body such as a barristers' chambers to take a protected characteristic into account when it's deciding who to recruit, who to offer opportunities to, who to promote, where individuals with the particular protected characteristic have been identified as either being underrepresented or at a disadvantage. It's only lawful to take positive action where the candidate for the role is as qualified as everybody else. And of course, the recruiting body is not allowed to positively discriminate. So it can't adopt a blanket policy of taking every black applicant that walks through the door and rejecting everybody else. The benefits of positive action are increasingly recognised, although the process itself is controversial. The Equality and Human Rights Commission, in its code of practice, identifies some of the benefits as being producing a wider pool of skilled and talented individuals, producing a dynamic and challenging workforce that's more able to withstand change, providing a better understanding in terms of the organisation of its foreign and global markets, and a better understanding of the needs of more diverse groups, both nationally and internationally. And chambers are slowly waking up to this. In particular, commercial chambers, who generally have work that takes them to a range of jurisdictions, have been very clear about the benefits of diverse membership. Some chambers have applied positive action measures in their recruitment. I'm not aware of any chambers that has done this on the basis of race. The only examples I'm aware of concern sex. But I think as we move forward, particularly in the current climate, there will be a greater willingness for chambers to do more, to be bolder, and to apply positive action measures, and also to state publicly that they're doing so. Because one of the things that sometimes happens is that sets adopt measures but don't tell anyone that they're adopting them because they're afraid of challenge. So where, for example, Grays and other inns can help, it is by endorsing positive action measures where they are appropriate and necessary. The final point that you mentioned was the one of targets. And if there has been a reasonable identification of disadvantage in the way that I've described, or of underrepresentation, then targets are one measure, one way in which an organisation can seek to address or redress the balance and the disparity. So generally speaking, targets are lawful, quotas are not. That's, if you like, a brief canter through the state of the art as it is now.
Well, thank you very much. I think it was quite important that we certainly had that bit of law. There won't be very much more, I suspect. But let's go straight to Kim. Can you tell us what you think of this aspect of the issue? You have to unmute, Kim.
I endorse what has just been said in relation to chambers being bolder and doing more as far as positive action is concerned. Sadly, I'm of the view that the pace of change has slowed and the impetus has been lost. Having been away from the United Kingdom's legal system for 4 years in the Caribbean, I am disappointed on my return by the lack of progress as far as positive action and chambers are concerned. Positive action is in use in some chambers, but not across the board. And this needs to be emphasised, widened and encouraged by the Inns through its senior members, many of whom are not only senior members of chambers, but often heads of chambers and indeed members of the judiciary. Some chambers use blind sifting in relation to pupillage application, which involve applicants being allocated numbers and names are removed in the initial sifting process. This is a step, in my view, as far as positive action is concerned and should be encouraged. Another example of positive action is to ensure that as many members of chambers as possible are involved in as many aspects of the selection processes to even out the application playing field as much as possible. Additionally, and it still has not happened, chambers and large city law firms should be actively discouraged in relation to the widespread practice of targeting pools of future graduates from Oxbridge, and there should be closer monitoring at pupillage fairs and other events as far as this aspect is concerned, in my view.
Thank you. Kwame.
Certainly, and I, again, would love to echo what Kim Hollis has said concerning the focus on Oxbridge students. Opportunities are often missed by chambers to find students and potential pupils because of the focus on Oxbridge, and by focusing on other universities and not just to recruit them for Oxbridge, is there an issue with my microphone?
Yes, there is actually. I wonder whether Sam might just tell us whether he's able to do anything with that, because we've missed quite a bit of that. I think he's just checking. We'll give it just a few moments and then we'll, if you can just summarize. We got quite a bit at the beginning, just the last two sentences, I think. So, Kwame, if you'd like to just continue now, I think. Kwame, can you hear me? What we will do, we'll come back to him rather than wait, because I'm sure that there may be others that we can hear. Can we have Fitzrene on this point, please?
I think positive action is difficult if you get to the application process, because what is your pool of applicants? Because it may be that there aren't any black or BAME. I'm not going to go into the intricacies of those words, but black or BAME applicants might not even be there for you to then look at them at pupillage and then at tenancy. Presumably, actually, the chamber should be looking at positive action at sort of a grassroots level. They should be looking before people get to Oxbridge at all. They should be looking at ensuring that the pool of applicants is widened before the things happen, i.e. the connections, the education that is required to be at the bar happens. And so I'm not keen on the idea of positive action or targets as at the application or at the pupillage or tenancy stage, but I'm very keen on it much earlier down the line. And I would hope that chambers would think about, and Greys of course will, think about ways in which we can do that when people are much, much younger before they look at the bar.
Thank you for that. Can we have Gelaga, please?
Thanks, Anesta. I agree with Kim. A lot has changed. It's certainly a very different profession to when you and I and others started. In the days when, you know, there were very few Black practitioners, and those that were in the profession had to confine themselves to chambers that nobody had any hesitation in describing as ghetto chambers. And it's disappointing that despite the fact that we have made so much progress, there's still a long way to go. And for reasons that I guess we all understand, in some ways we're going backwards. So I actually firmly believe that there should be targets, because I think the time has now come where uncomfortable discussions need to be had, and uncomfortable decisions need to be made. And I think that if you do not have a system such as targets, then progress will continue to be slow. And there's a possibility that we will even go backwards. I see nothing wrong with it being a target of the end, that certain criteria need to be met in filling positions, nor should there be a difficulty with chambers making it a target that they should, in their recruitment and selection processes, ensure that of the people who are being interviewed, they have a sufficient pool to meet those targets.
Is there a risk, though, Gelaga, that a BAME lawyer will feel a little embarrassed? This chamber's got targets, so they're not really looking individually at me and my assets. Isn't that a possible criticism?
Well, I think any lawyer who is confident in their ability and is good is not going to be put off by the fact that detractors might try to label them as a token. The fact of the matter is that there are very many competent and good lawyers who do not get a look in. You know, we previously, before a lot of the reforms that we now had a system of a tap on the shoulder or the old boys network, and nobody suggested that many of the very competent people who benefited from that system were there simply because of their connections and that they did not have the ability. And if, as a result of targets, more and more competent people of diverse backgrounds enter the profession, there will ultimately come a need when targets are not needed, but we're not there yet.
Thank you. Let's go back to Kwame, and I hope we can now hear you. If you can just, we did catch the first two sentences, so if you want to go on to make your points, if you can.
Excellent, thank you, and I hope you can hear me a bit better now.
Yes, we can.
Certainly. So the point I was making was to piggyback again off the initial statement that was raised, and it is important for chambers not to centre their focus on Oxbridge applicants. And as we've seen through the statistics of pupils recruited over the past 10, 15, 20 years, a significant proportion does come from Oxbridge universities. And the importance of this isn't just to ensure that the bar is diverse, but it's also to ensure that the bar keeps up with changing social and legal climates. The increase of direct access work means that clients are going to be looking for barristers that they can directly relate to. They are looking for barristers that can have a greater understanding of their personal situations. And by ensuring that chambers have a diverse pool of tenants, it also ensures that chambers is able to keep up with the changing climate, and they will be able to, and as the bar will be able to stay relevant for years to come.
But I ought to add this. I mean, chambers are allowed, aren't they? If they consider they want the best, they go to what is still considered to be the best two universities, Oxford and Cambridge. So we agree they're allowed to do that, aren't we? Well, I'm going to take this over to Saud. What about that? I mean, I don't know. Do your chambers go to Oxbridge? And no doubt you'd say that's lawful. They're allowed to do that.
Well, our policy is to treat a first as a first. So there's no distinction drawn between whether you've got a first from Oxbridge or a first from another university. And we do blind sifting and various of the other techniques that are used by that other panelists have mentioned. But I think I'm sort of wearing two hats, because I'm a commercial barrister. I'm also co-chair of the Equality and Diversity Committee at the Bar Council. And I want to sort of slightly strike a positive note about positive action, because there has been for a long time a focus on having fair and objective recruitment policies. And I think that one can detect, certainly anecdotally, a much greater commitment in recent years to, or desire to have chambers that represent society, and to take much more positive steps, or to do more than simply having a fair system, and to do whatever they can within the limits of the law to increase representation. And so we do see that with more steps taken for positive action. not simply doing something that can be defensible as objective. And there is quite a lot of work currently being done about positive action to assist chambers in guidance about that. And in the specific context of Black Lives Matter, there is a race working group now inspired by that, which is very much looking to publicise and promote within all chambers the steps that they can take to ensure that they do become representative. So I think, as all will agree, there's a long way to go, but
Yes.
there is, I think, a degree of momentum behind going that extra step in order to achieve the representation that we want.
I'll just add this point. There's going to be a much larger number of BAME lawyers who just don't get to Oxford. They don't get there because of their disadvantaged background. So
Well,
less firsts.
I completely agree with that, and that is why, perhaps we can come on to it in relation to some other questions.
Yes,
but
I think
that is why I would endorse what Fitzrene was saying, which is you've really got to get in there early. You've got to be championing and promoting and encouraging these people that a career at the bar is a career for them at an early stage before they apply for university. But also, when you are looking at people's applications, you need to take into account the degree of deprivation that they may have had in their upbringing, because you may have somebody who's got straight A stars, but that's pretty much what they were expected to get given the educational advantage that they had. Or you may have somebody who got straight A stars from one of the worst performing schools in the country. And there's a difference between those two achievements.
Thank you. I think we've got it timed just to bring Ijeoma in. Thank you.
Thank you, Anesta. I just wanted to say, just in terms of taking it back to Chambers and taking it back to Grays, one of the things that is important is for Chambers to reflect on what makes a good and effective practitioner. And that isn't just about having a first or a starred first or 5 firsts or whatever it happens to be. It does involve looking at what the work that Chambers does requires, what skills and experience it requires, and building that into the selection process and assessing that. And that is a way that enables people who have not had a private education or have been to Oxford or whatever to demonstrate their competency in relation to the tasks and the actions that barristers routinely carry out. So moving towards an assessment which is based on relevant competencies for being a barrister would, I think, be a major step forward in terms of improving access to Black and BAME candidates.
Thank you. Well, that's a big topic, I know, that we can debate until midnight, but we won't all be here at midnight. So I'm going to take the next question. All 4 Inns play a role in the life of every student who is admitted to the Inn. So the question is this: can you think of one thing that Gray's Inn can do, or one thing they can improve on, in order to help law students to get a pupillage? And in particular, we are clearly thinking of BAME law students. So Kwame, we'll kick off with you on this, please.
Certainly. Thank you again, Anesta, for the question and for including this as part of the panel. It's, as we established earlier, it's maybe the most important stage of somebody's journey towards making a career at the bar. And I think it's first important to establish what the role of the Inn is. The Inn's role is to educate and train its members. And a key aspect of that training, I think, is missing. And it's training pupillage committees to be able to value applicants from non-traditional backgrounds. And it's, again, important to establish that the Inn does provide a lot of concrete support to all students, such as scholarships, mentoring, marshalling, and application reviews. But as I mentioned before, it's evidenced in the pupillage recruitment statistics each year that there still remains a bias towards the traditional applicant. And that traditional applicant would, of course, be a white Oxbridge student. And in order to combat this, I believe Gray's Inn needs to, again, make a concerted effort to champion the value of barristers from non-traditional backgrounds. And what can be done immediately to address this is ensuring that panels at practitioner events are made up of people from diverse backgrounds. This ensures that practitioners who are part of these panels are seeing that people from non-traditional backgrounds add value to the bar. And perhaps my favorite suggestion for how this can be enacted immediately is by celebrating the work of Black and Asian barristers by having some of their paintings available to see in the hall.
Thank you very much for that. Can we follow Kwame with Fitzrene? Oh, I'm sorry. No, my batting order is Kim next.
Kim, you're on mute.
I have to unmute, Kim. Thank you.
Yeah, I agree with everything that Kwame says, and in particular in relation to the education process as far as the IN is concerned. But I'd like to approach it from a slightly different angle. I feel that CV and pupillage application clinics have a very strong role to play in this respect, and have demonstrated that mentoring and practical assistance in the application process has had a tangible, real effect. It's been demonstrated by clinics that were held years ago by the Association of Women Barristers. I think the IN should consider incorporating the application process in relation to pupillage as an integral and essential part of its education program, which in my view, having just returned from the Caribbean, would serve the dual purpose of not only equipping its students in the United Kingdom, but those returning to their countries of origin to practice, to help them as well when they return. Because one of the things I noted whilst I was away is that I feel that far more needs to be done in relation to outreach as far as those overseas students are concerned, as they seem to be presently lost to the IN post-call. But that is a conversation for another time. There are a lot of benefits if we actually outreach to them, and I know they want to remain a part of the IN, and there are a lot of benefits, some of which have already been alluded to by Ijeoma earlier in relation to chambers and increasing its diversity and its global practicing views, etc. So those are my views.
Thank you. Next, Gelaga.
Well, I think if you want to know what the IN can do to improve things for students, you can do no better than ask a student. So I agree with what Kwame has said. I think Gray's Inn actually does a lot for students, and Gray's Inn over the last few years has taken great strides in improving the way that we approach issues of equality and diversity, whether it be in the way in which we have reappraised the scholarship process to make sure that there is a balance and that it is not just weighted in favor of Oxbridge students, but we also take into account things like life experience, so that, for instance, a single mother who has raised a child is weighted quite highly in any application for scholarships. And so practical things like that have been introduced by the IN. But I think that the point that Kwame makes is one that we as an IN need to take on board. That when you walk around the halls and you visit the hall, you do not see a diverse range of portraits. And there is actually no reason why the IN cannot address that. The IN is obviously an international IN. We have BAME members from all over the globe, some of whom hold and have held very high office and prominent positions. And maybe the time has come for us to think inwardly and maybe have uncomfortable decisions as to whether it's time we reflect our wider membership.
Thank you, Gelaga. Fitzrene?
I think I'd expand upon that. I entirely agree that representation is very important, and Grays does some great initiatives like that actually start, I sound a bit like a broken record, but start at grassroots. They start with 14, 15-year-olds who are coming in and getting their very first experience of advocacy, and that is a great thing to do. But when I think about it in the light of what we're dealing with now, do I want to just see representation? Do I want to just see, here is a woman or a man who looks like me, and therefore I can be there? Yes, I do. But on top of that, I want to see people who are the allies saying, you're welcome here. We appreciate you. We know who you are. We understand what you're going through. And therefore, this is a place where you can come and be welcome, not just a place where there are others who look like you, but a place where there is an even playing field. I think maybe culturally that's a change that could be made, rather than simply being, here we go, there is a black person or there is a BAME person there. So that's what I think could probably be changed.
Thank you for that. Saud.
So I'll be very brief because everybody else has spoken very eloquently, and I agree with what they say. Kwame mentioned what the IN can do is championing non-traditional backgrounds, and that I agree with that. What the IN can also do is champion individuals from non-traditional backgrounds. The IN sees people a lot earlier than chambers see people. They can spot people who are really going to succeed, and they can nurture them and give them the help in fulfilling their applications, getting their mooting, all sorts of things that will maximize the ability through championing individuals that they will get a pupillage.
Thank you. Ijeoma. Ijeoma?
Thanks. I don't think I've got, well, I could add, but I won't. I agree with much of what's been said. And I think the last point that Saad made is particularly important in terms of the IN's role, championing individuals. It's important that that happens more. It happens already, but it needs to happen more. It needs to happen consistently and transparently. And it will, I'm sure, garner results.
Just want to see if we've got one relevant question here that might, yes, I'll read it out. Just because the old boy network would give a tap on the shoulder, etc., shouldn't mean that the BAME situation should be the same, as long as the best talent comes through. Just one person who may want to pick up on that.
Well, I think I referred to the old boy network, and what I certainly wasn't doing was saying that people should be chosen as tokens. The issue is not whether the particular applicant is competent. That's a given. The whole issue is about creating a level playing field. And so nobody would suggest that an ethnic minority practitioner who's not competent should be recruited or promoted. But what we do say is that those who are competent and those who have the ability should not be hindered simply because of the color of their skin. And that when decisions are being made that affect whether or not they're recruited and affect whether or not they progress and affect whether or not they're treated fairly, those decisions should be made on merit and should not be, they should not suffer a disadvantage because of their ethnicity.
Thank you. That takes us to the next question. Taking one aspect of life as a tenant, explain why this is a greater disadvantage to BAME lawyers, and tell us whether you think at all that the IN can help, because we are now in the realms of a business being run by chambers, etc. So I'd like Saud to go off with this one, please.
Thanks, Anesta. I think we have to recognise that career development doesn't end when you gain tenancy. There are many issues that are faced by junior tenants, access to work, working hours, financial issues, relationship with colleagues, and so on. These are issues that I think tend to affect BAME lawyers slightly differently from the way in which they do people who are coming from perhaps a more traditional background where they are very familiar or know very many people who they can turn to who are very familiar with how these issues arise and how they might work. And so what the IN can do is to provide through mentoring somebody outside a person's chambers who they can continue to go to in the junior stages of tenancy to talk about those issues and gain the sort of experience and second views that to others may be readily available. And that, I think, is something that is it's very useful for the inn as being outside chambers where these issues can be difficult to raise with other colleagues, and they can provide a useful resource.
Thank you. Kim?
Well, I'm going to speak obviously from my experience as far as the criminal bar is concerned. And I found and still find that the networking in relation to work opportunities and socialising with solicitors after chambers hours can be particularly difficult, not only for women, but those specifically from stricter cultural backgrounds. It's not uncommon, and I think it still is, unfortunately, the case, where the emphasis is for events in relation to work to centre around a drinking or sporting culture, such as football or cricket matches, which inevitably not only excludes the majority of women, but are difficult to navigate if you are from a non-drinking culture or not a supporter of a specific well-known football club, or do not have a particular interest in the sport in question. It's what happens outside the workplace as well as inside the workplace where I do feel that there is a specific disadvantage and where a balance needs to be struck. As to what the inn can do, obviously the inn can only intervene to a limited extent because after all, how Chambers runs itself is in relation to Chambers. But I return to my answer in relation to question 1, namely by outreach events, including those organisations that we've all spoken about earlier that have been formed in order to assist in relation to diversity, such as the Black Lawyers Network, the Society of Asian Lawyers, and other organisations such as those.
Thank you. Ijeoma, well, we can't stop men talking about football, can we? I mean, Kim makes a proper point, of course, but football is always going to be football.
Yeah.
So, Ijeoma.
Thank you. Women talk about football too, but what I wanted to say, we've spoken about some of the obvious disadvantages of a BAME tenant. One of the things that I want to talk about, again, pulling it back to what the inn can do, is that it's a consequence of there being a lack of diversity within an organisation. If there are only 1 or 2 Black or BAME individuals in a set, those individuals can feel under pressure either to take the lead in promoting diversity and challenging discrimination, or indeed by burying their cultural differences and trying to fit in inverted commas. So one of the things that arises from that is a discomfort around talking about race, and therefore a reluctance to talk about race and culture and ethnicity. If we don't speak about it, and if we don't enable those conversations to happen, then there is a lack of connection and a lack of empathy when individuals who may be experiencing difficulties try to share their lived experience. So one of the things I think that Grays can and should do is to be a space where some of those difficult conversations can be had, and to be an empathetic environment, to be a listening environment, because, and I'm going to, one of the things that people sometimes have said in the past is, well, we don't see race, we're not interested in race, it doesn't concern us, it doesn't bother us. But to my mind, seeing race is essential if we want to change anything. And so enabling people to see, to listen and to understand is something that of course Chambers can do, but that Grays and other inns should also take on board and try and do, so that we can begin to make real change. I saw someone was asking about, making systemic changes. And it seems to me that unless one sees race and begins to talk about it in an open and fearless way, we are doomed to repeat the missteps and the mistakes of the recent past.
I just want to throw this in because it's relevant to do it. I mean, there will be some chambers that think, well, we have a separate entity here. This is a business. We've got heads of chambers. We have a excellent running clerk's room, and we don't need the inn to talk to us about race. That might be one of the reactions you'll get. Anybody want to come back on that? Saud.
Well, I think, as I understand Ijeoma's point, it's out of the recognition that it may be slightly difficult to have some of these conversations in your chambers because you may be one of a very small number of people, and it may be a chambers which is not accustomed to discussing such matters. But what Grays can provide, along with the other inns, is a wider framework that isn't specific to one business. And so even if it isn't the inns telling the chambers how they should conduct their affairs, nonetheless, membership of the inn and the organisation of events and discussion amongst members of the inn, where people can see race and have difficult conversations, is an incredibly useful thing to do. Almost more so if it's not happening within your chambers, would be my take on it.
Thank you very much for that. Let's just see if we've gone through everybody on that aspect of tenancy. Fitzrene, do you have anything to add?
Just briefly, because I think Ijeoma hit the nail on the head. It really is going to be another space in which you can have that conversation if there isn't that ability to do that in your own chambers. So really for Grays, it will be about, as Saud says, having those places in which we can have different conversations so that we are ensuring that Grays from top to bottom is going to be somewhere anyone can have that conversation, no matter what the makeup is of their chambers. So that's all I'd say on that.
Thank you. Gelaga.
I agree with everything that has been said, and I think actually it is a subject that comes up very often from middle and senior BAME practitioners in terms of how they're perceived. And I think if the inn and the inns can become a space in which those who find themselves in a position where they feel isolated, you will find many BAME practitioners will tell you that when it comes to progression, they hit a brick wall, because very often the fact that they're from an ethnic minority means that they're perceived as less competent and less able. They're challenged in a particular direction. They're not given access to the good quality, well-paid work. They're not given access to the blue chip firms of solicitors who are instructing. And so if they don't have their own individual network and their own support services, they struggle. And you find that as a result of that, many competent practitioners who've been practicing for many years leave because they feel they've hit that ceiling. And very often they encounter problems and feel unable to resolve them because they don't have the necessary supports that would allow them to be able to express what they really feel and to articulate the difficulties that they face. And I think actually that is something that the inn could look at putting into place so that certainly those who find themselves in that position have allies of strength. And the inn is well placed to fulfill that role, because clearly we have a membership of people who are suitable and qualified to provide that sort of space for those who need it.
Okay, thank you. And Kwame, I know you're not a tenant, but if you want to add anything, if you can do that shortly, that will be great.
I think I would defer to those of greater experience, and I think the points put forward have been spot on from my limited perspective.
Thank you very much for that. So we'll swiftly move to question 5. Looking at the wider public outside of the bar, many of whom joined in the recent protest in support of Black Lives Matter. In your experience, which aspect of law, when applied to the many BAME individuals cause much angst and unfairness. And how can such unfairness be removed? We're going to start with Kim, please.
Well, there has to be the mention of stop and search at this point in the discussion. It's my view that the threshold for stop and search needs urgent reconsideration by Parliament, and whether a different or higher test is necessary. The provisions that are used today are nearly 40 years old, and with some amendments, only slight amendments, the powers are applied as they were drafted in 1984 on the back of the Brixton and Tottenham riots. As recently as June of this year, it was noted that the long-standing disparity in the search rate by ethnicity continues to ensure that BAME people are disproportionately affected by the negative effects of stop and search, as they were 4 times more likely to be searched in 2018-19, which was particularly pronounced for Black people, who were 10 times more likely to be searched than white people. In order to highlight and emphasize, it is significant in my view that there is little evidence to suggest that stop and search provides an effective overall deterrent to offending. It is estimated that only 8% of all 2018-19 arrests were generated by stop and search. A lot of work needs to be done in relation to this. The police need to reform their approach with the assistance and cooperation of the communities through mutual education and support. It's clearly not working at present and needs a new balanced approach, balancing the public interest on the one side against the need to fight crime. I know it's controversial, but it needs to be spoken about and it needs to be out there. It's already in the open. So those are my views.
Thank you. I'm just, because we're running slightly out of time and we're very interested in quite a number of questions that are coming through. We want to get our audience involved. Gelaga, do you want to come in on this, or anyone else actually? It doesn't have to be somebody that's a criminal practitioner. Would anybody be very keen for this? Just a show of hands.
I'll be brief. I'll just say
Yes,
that
please.
I think one of the things that's causing the most angst at the moment is this issue of profiling. And actually, it's not restricted to the criminal law. That, you know, you look at issues in housing, in education, in health. There is an issue about profiling that results in people being treated in a way that is at worst discriminatory and at best perhaps insensitive. And I think the way that you resolve that is by those who lead the institutions that are coming under the attack to be less defensive and to perhaps gain an insight into why certain things happen, and therefore to understand the problems. And because only by understanding what the problem is can you have an effective solution.
Okay, thank you for that. Our last question. Take one example, please, of good practice at the bar, other than positive action, that you have come across at the bar or in any other legal establishment which increases the opportunity for BAME tenants and pupils to succeed at the bar. And if you can, tell us what Gray's Inn can do to help. So, Fitzrene, please.
I've seen some examples, certainly the ones I can think of are in criminal sets, but where they have effectively the management committee, so ManCom that we would know of, looks at distribution of work, and that's both the distribution of how much work, it's who the solicitors are, it's how much is being paid, to ensure there's across the board, say it could be in, I don't know, tenants between 1 and 3 years core, it could be pupils, it could be 5 and 7 years core, but that in bands, there is a check and balance as to who is getting what work and who is getting what opportunities. Because of course, we all know the bar is in some ways down to reputation, but if you haven't had the opportunity to build your reputation because you're just not getting the work, or not getting the work for what Gelaga described as the blue chip solicitors, then how are you going to build that reputation at all? And of course, that's going to work for all sorts of discrimination, not just race. It could be on the basis of sex, it could be on the basis of working parents, but it does mean that everyone is held accountable And that's certainly a way of dealing with ensuring everyone's got an equal playing field in which to really build their career at the bar.
Thank you for that. Can I bring in Saud just briefly, please, if I may, on that?
Thanks, Anesta. So I completely agree with the point that Fitzrene makes, by the way. I was going to make a slightly different point at a different stage, which is the pupillage stage, from my own experience, which is, I alluded to it earlier, but we've wanted for a while to be able to take account of people who have excelled in difficult circumstances, but it's very difficult sometimes to see that from a CV. And what we've been using this year, which a number of chambers have been using, and I hope it grows, is something called rare recruitment, which essentially looks at measures of whether somebody has come from a particularly deprived background, from a non-traditional background, whether they have excelled relative to the quality of their schooling, for example. Are they in a school that has had the amongst the worst sort of bottom 10% of results, for example. And using that gives an objective means to actually see how well somebody really, truly has done, given their circumstances. And it gives an ability, and a much increased ability, to take account of that in the selection process and enable people who might otherwise not have got through to an interview stage to do so. And then they can perform an interview and you can see what a high quality candidate they are.
Thank you for that. I just want to find a question from Alex Carlisle. He says, well, I hope we all agree broadly about these issues, but what more can or should Gray's Inn do to achieve true diversity and equality? I just put that out there in case there's any other additional point that any of you want to add, because we are going to go into one or two other questions. Does anybody else want to add anything else? Because I think you've all brought the in where you say you can. What can heads of chambers specifically do? Because we all know the hierarchy that happens. There is a head of chambers, and that person can and often does influence politics and procedures in chambers. Anybody wants to come in on that? If you just show me your hand. Saud, followed by Ijeoma again, I think. So
the first thing a chambers needs to do is it needs to know itself. So heads of chambers can make sure that they are monitoring, they are collecting their statistics, and they are assessing them, so that they know whether there is a serious shortfall within their chambers. They know whether work is being spread in ways that are differential, because until you know, you can't act. But I would also say, picking up Ijeoma's point, it really is incredibly important that people get equality and diversity training. And I think in most chambers, people who are involved in the interview panels, that will happen. But there's no reason why it shouldn't go much broader than that. It's something that benefits everyone. And there are loads of programs from the Bar Council, for example, to deliver that. And they do so most days of the week.
Thank you for that. I'll read this question. I'm not so sure that we have the time to deal with it, but it's a big and I think interesting question. Where does responsibility ultimately lie for dismantling the systems and institutions that prop up and indeed benefit from racial injustice? I hope I'm fairly right in saying that's really a big topic that we may not be able to deal with this today, but I think it was a very important question, so I've read it out. I want to also make mention of I think a valid question, which is that the outreach committee, which is going to continue after this webinar to pick up on matters raised here and to take forward the Gray's Inn initiatives about Black Lives Matter. The question said, well, most chambers are in London and the inns are in London. Will the outreach program cater for those outside of London? Well, I'm going to be brave and say, yes, it should and it will. thank you for pointing that out, whoever did. It's a very important point to have pointed out. May I just, we are miraculously 18:19, so we've got a few more minutes. I just want to check that there are some more interesting questions that our panel may want to have. Yes, I should have specifically said Alex Carlisle's note was 2 leading criminal sets do not allow applicants with pupillage to identify their university at all. Do you think it is a helpful approach for achieving diversity? Well, I think we've answered that, and we've gone further by Ijeoma's answer in relation to that. Representation within the profession is one thing, progression up the ladder is another. What can be done to support progression? Well, again, I believe we touched on those rather important factors. Nicole Rushton QC said this, the latest pupillage gateway statistics show that while the proportion of BAME applicants is representative of the working population, this proportion falls dramatically at every stage of the selection process. So the proportion of pupils selected is far lower. What does the panel think is still going on? Question mark. Who'd like to take that? We've got room for 2. Yeah, Kwame, followed by, well, we'll start with Kwame, and then Fitzrene.
So I think this goes back to the point that I've tried to make a number of times throughout this panel, and it's the importance of championing people from different backgrounds. And again, it sounds like I'm banging the same drum, but it truly is important. And it even touches on the issue of blanking out somebody's university place or somebody's name or other identifying factors. Because even if you do that, there are still other social cues that can indicate what kind of background somebody comes from. So to give an example, if the inn is able to show that a person who has helped a parent or another family member with an immigration application or with a housing issue when a family member has been made homeless, if we're able to show that people with these experiences, which are often isolated to people from poorer or minority ethnic backgrounds, if the inn is able to show the value of these experiences, then when pupillage committees are making decisions on pupillage, they'll be able to see certain experiences that people have and not just give a higher value to the person who has won a mooting competition or who has come through the traditional channels. So again, to conclude, there has to be a focus on showing chambers the value of people with non-traditional backgrounds and non-traditional experiences.
And I think Fitzrene wanted to come in here. I'm beginning to think actually that there are a lot of BAME backgrounds which are pretty traditional now, but just slightly different from others. So I appreciate the word you use, traditional, but I think there are enough of us here that our backgrounds are pretty traditional too. But Fitzrene.
I'd say in terms of why we're losing people at each stage, there's probably the easy answer and the hard answer. The hard answer underlies the easy one. The easy answer is perhaps they aren't meeting standards that chambers require. The harder answer is prejudice. And that might not be prejudice at the stage that you're doing the application. It might be prejudice so much further along the line where they are not getting into whatever institution, they are not getting the grades, they're not having the connections to get them mini pupillage or to get them marshalling, and they don't know anyone or they don't know how to do it because they can't access it. And so it'd be very easy for people to say, well, it's because they didn't meet a particular standard. We need to look at why we have such a proportion of BAME applicants not meeting a particular standard, if that is what is causing them to drop off as and when.
Might it be a suggestion for our inn that we might want to go back and look at the statistics and the information that's being gathered about what happens to their students up to pupillage, up to new practitioner, and maybe have a look at those questions on the form and see whether we might put some more in or slightly different ones. But that's a suggestion. If anybody thinks I was wrong about that, do say. A note came through from someone who Said, please do.
Thanks, Anesta. You were mentioning statistics.
Yes.
I think I may be wrong, and I don't have the very latest statistics to hand, but it's a slightly strange picture in that the percentage of BAME barristers at 0 to 7 years call is around about 12 to 13%. So it's more or less reflective of the general population. But it's also the case that a white candidate has twice the chance of getting pupillage compared to a black candidate statistically. And so what we have at the moment is there is a broadly representational cohort at the very junior end of the bar, but we are in danger of losing it. In particular, if these statistics can continue. And of course, that is something that is only made worse by coronavirus, which is going to put off people who are disproportionately put off people from non-traditional backgrounds.
I should add a point. Sorry, Ijeoma, you want to come in?
No, I was going to be on a slightly different topic, Anesta, so I won't interrupt.
No, please do. I think it's important that we hear everybody. We've got a little bit of time.
Okay, it was just in relation to what can heads of chambers do, and Said answered that. I just wanted to add to that in terms of concrete things. Obviously, the first thing is to lead by example, but secondly, I think this notion of sponsorship, so creating opportunities and connections for career progression for people within their set, but focusing on Black and BAME practitioners within their set. Sponsors then advocate for those individuals in conversations where the individual themselves is not present. So, for example, might put forward an individual to a solicitor, introduce them to a solicitor who sends them work, might seek to broaden their practice, develop their relationships with individuals that they already know, so that they are effectively proactively identifying and developing their tenants. They are opening up their own professional networks and opportunities to their tenants, and they are supporting their career progression. So it's a development of the mentoring relationship into something that's much more specific and targeted once practitioners are into tenancy and wanting to progress. Conversations about where next, judicial appointments or areas of work that might be explored. All of those things are conversations that can happen within a sponsorship relationship. And that's something that heads of chambers and also senior members of chambers are really well placed to do.
Yeah. Can I mention something we haven't touched on, although I'm sure it's been in our minds? Unconscious bias is something no doubt you're all going to agree is quite important with those who make decisions on interviewing committees at any stage of a BAME person's progress from student right the way up. Difficult one to deal with, do you think? A member of chambers may appear very balanced, pretty fair, but it's a different matter when one's looking underneath the character to discover where unconscious bias might slip in. I've got time for 2 other comments on that, if anybody would like to touch upon it, deal with it. Fitzrene.
I was just going to very briefly say, so maybe you can fit someone in after me. When I said prejudice, it's exactly what I mean. So it may not be actual prejudice, it may just be unconscious. And the way to deal with that is the kind of person who is genuine, who doesn't know they have a bias, is hopefully the kind of person who's going to come to something like this, who's going to listen and understand different points of view and work on it from that basis. So mine was more of a correction to what I was saying earlier.
Yes. I should add, a note came through that there is no white representative on this panel. And I have to say that was absolutely deliberate, because in starting the progress for Gray's Inn, considering Black Lives Matter, they wanted to hear from a selection, a mixture of BAME lawyers. But it is undoubtedly the plan of the Inn that through the outreach group, that will be widely representative of those within the inn. So I hope I have dealt with that perfectly proper point that was raised by someone who's listening to this debate. So we are a minute away from 6:30. I just want to see whether there are any other questions I might ask our panel. We have dealt with this, but I think it's only right to read it out. Lawrence Cohen said that Ijeoma's point seems really important. Ijeoma, it might be a point you made earlier, I'm afraid. Does she agree that more white members of the bar attending Black lawyers' events and listening is an important step in acknowledging the problems and starting to deal with them? I think as a general point, does anybody want to come in there? That's someone agreeing with, yeah, Gelaga, if it can be short, please.
I'll try and be short. I agree with that. I mean, many of you will remember the late Judge Henry Brooks, who was one of the...
If you can just speak up slightly.
Yeah, I was saying that I agree with that. Henry Brooks, when he started the Race Relations Committee of the Bar Council, and when he delivered his Capilla lecture, made the point that after 7 years, he still did not consider himself an expert, and how important it was to listen and change things. And he used that as a vehicle to drive through important changes. So it takes us back to where we started. I think, you know, we all have a stake in this and we all have to drive it forward.
Absolutely. Now, I'm hoping we are going to be able to find our treasurer to bring things to a close, as it is 1 minute past 6:30. We've done very good timing, I believe. It may be that I close it, but I ought to hand over to our treasurer, please.
Well, what I'm going to do is to say thank you. There've been a great number of interesting points, and we will take them away and think about them, notably in Ijeoma's group. I think that some of the points are obviously practicable. Approaches to practical recruitment practices, to the way chambers think about themselves. Some are much more difficult. How the inn can act to affect the processes by which the better thought of universities recruit. That's a pretty tall option for the inn to influence. And so I think it needs a careful debriefing session. We will have that. But my main message is thank you very much to all of you.
Well, and can I thank the inn for this initiative? It was a very important, timely initiative. And I know that all of us who have listened to the panel would join me in thanking our panel. Gelaga, Fitzrene, Saud, Ijeoma, Kwame, and King. They've given up their time and they've shared their experience on some very difficult issues, but we're grateful for that, and we thank them all. And we look forward to the work that Gray's Inn will do. Clearly, there's commitment from our treasurer and the rest of Gray's Inn through the new committee, the outreach committee that's been set up that will operate for in and outside of London. And we look forward to that work. Thank you all. I don't know whether it's possible, Treasurer, to say that, that this will be around for a few weeks, not very long, the recording. If people feel that they want to send in any other comments, I'm not so sure how that's going to be done, but perhaps there may be some mechanism where people can still send comments in who weren't here tonight.
Well, as I understand it, it will be available for some weeks from the website, so people are very welcome to re-look at it or to ask their friends and colleagues to look at it. I'm afraid to say messages probably need to go to the new chair of the new outreach group.
Yes, well, that's a good idea,
to
put it that way. Well, thank you. I didn't want people to feel that they were not able to say things that they thought might be helpful. And of course, all will be considered. Not everything can be actioned, but it'll all be considered. Thank you once again. We have thank yous from a number of people, thanking the panel Let me know how I can help. Very happy to support in any way. That's from somebody called Anne. So those are some positive comments that have been made. Thank you very much, Treasurer. I think time to go home.
Good night to you all.